Greetings, folks. Bill O'Leary here coming to you. And in this video, I'm going to be addressing the question, well, what's the best do-it-yourself way to create a simple living trust? So in this video, you're going to learn three things. One, what a do-it-yourself trust is. One. Two, why using a do-it-yourself trust is a really bad idea. And three, a real-life story of a form-type will gone bad. Quick introduction. Again, Bill O'Leary. I'm an estate planning attorney, wills and trusts, probate, trust administration, elder law, and my firm is Legacy Planning Law Group in Jacksonville, Florida. So what is the best way to create a do-it-yourself living trust? Is there a good way? Well, let me answer it this way. Would you diagnose and treat a disease yourself, or would you go to a doctor? Well, obviously, you go to a doctor, so you wouldn't try that at home. Doctors are trained over many years to help you with your medical needs. Same thing with a lawyer, many years of training to help you with your legal needs. The bottom line is there's no good way to create a living trust for yourself. You're simply asking for trouble. And by the way, don't be fooled by slick advertising. You know, LegalZoom, Rocket Lawyer, and other online tools. They may be good at advertising, but not much else in my professional view. Well, so let me tell you a real life story. A woman by the name of Anne Aldridge, she used a legal form to give away at her death certain items she had listed on the form. Now, the form did not include a very important, very basic legal provision called a residuary clause. And this kind of legal provision says who's going to get the assets that are not specifically listed in the will. Well, Anne, she had specifically listed the primary assets of her estate to go to her sister. And then Anne went on to say in this form that if her sister was not living, then those assets would go to her brother. Well, after Anne did her form will, Anne's sister died. And before Anne, again, she died before Anne passed away. That was the order of events. Well, interestingly, Anne's sister, again, who passed away before Anne, Anne's sister left all of her estate to Anne. Sort of went both ways. Anne's brother was appointed the executor of the estate. Now, when Anne died, she had other assets that were not on the list of assets going to her sister. These other assets that were not listed included the assets that Anne received from her deceased sister's estate. You see, Anne's brother then tried to distribute those other assets to himself on the basis that Anne's do-it-yourself will listed him as the alternate or backup beneficiary of the specifically listed assets. Well, guess what? At that point, Anne's brother got pushback from two of Anne's nieces. These nieces were children of another of Anne's brothers who had predeceased Anne. The nieces made a claim in Anne's estate that they should get part of the assets that were not specifically listed. And the nieces argued that since the form will did not say who would get the sort of the remaining assets, the intestacy laws of the state should govern. Intestacy laws, what they do is they lay out who should get a deceased person's estate if he died without a will. Under the Florida intestacy laws, the nieces would be included as beneficiaries of the unlisted assets. Anne's brother said that the intestacy laws should not apply. His argument was that it was obvious, Anne's obvious intent that he should get everything. And he pointed to a handwritten note that Anne had prepared after she did the form will and before she died. And in this note, Anne said that she was giving all of her property to her brother. The handwritten note didn't meet the very specific signing and execution requirements under Florida law. Well, what happened next? You guessed it, a lawsuit. And a nasty one at that. The case was fought in the trial court. Didn't stop there. It went to the Court of Appeals. Didn't stop there. It went all the way to the Florida Supreme Court. Imagine the legal fees. And the Supreme Court ruled in favor of the nieces. even though by all accounts, Anne wanted everything to go to her brother. The court held that Anne's other assets passed under the intestacy laws rather than to Anne's brother, and so hence the nieces got part of them. Interestingly, one of the Supreme Court justices went ahead and wrote in a separate legal opinion that the case, quote, highlights a cautionary tale of the potential dangers of utilizing pre-printed forms and online tools and drafting a will without legal assistance, and reminds me of the old adage, penny wise and pound foolish. While form wills and other estate planning documents are readily for purchase online, everyone should keep this cautionary tale in mind. The Florida Supreme Court ruled that Anne's will was inadequate. And of course, how was Anne supposed to know? She trusted the provider of the form. She trusted their competence. Well, and who paid the price for the glaring mistake? Not the provider of the form. No, the family paid the price. Not only the price of Anne's assets passing in an unattended way, but also the price in attorney's fees that ended up far exceeding the cost of using a lawyer in the first place to get it done right. And by the way, this is not the only case of an online will or trust not working when it's needed most, which of course is when you die. Remember that the form may not fit your individualized circumstances, and it will certainly not tell you about potential pitfalls. In fact, LegalZoom and others, they don't give you legal advice. In fact, they go out of their way to say, hey, we are not your lawyer, we're not giving you legal advice. So it's kind of like going online to fix a medical condition or maybe a broken arm. Could you possibly find some relevant information online about the broken arm and maybe how to fix it? Sure. Now, might you mess yourself up by trying to fix the broken arm yourself without medical guidance? Well, I think you know the answer. So look, there's a reason why doctors and lawyers have to endure so much formal education, pass a very rigorous exam at the end of their schooling, and have years and years of practical training and experience, all in order to be effective. There's a reason. There is no substitute for getting the advice and counsel of an experienced attorney. So if you'd like to know a little bit more about why a do-it-yourself will is so dangerous and maybe how we can help, we'd love to talk to you. So we would invite you to schedule a free discovery phone call, we call it. And so go ahead and go to the bottom of this video. There's a link, click on it, and it'll take you right to our booking calendar. Just pick a day and time that works and we'll jump on the call. If you'd like to know more information about some other similar topics, do subscribe to our YouTube channel, Legacy Planning Law Group. So this is Bill O'Leary signing off for now. Go make it a great day and a better world.